Is your non-compete agreement actually enforceable? Imagine signing a contract that stops you from working in your field for months or even years. You might wonder if that agreement really holds up in court. Well, the truth is, not all non-compete agreements are enforceable. It depends on a few key factors. First, the agreement must protect a legitimate business interest. That means your employer needs a valid reason to restrict your work. Common reasons include safeguarding trade secrets, confidential information, or important client relationships. If the restriction is just to limit your options without a real reason, it might not be enforceable. Next, the restrictions need to be reasonable. Reasonable means they make sense in time, place, and what you are allowed to do. For example, a non-compete that lasts 6 months or less is usually seen as fair. If it lasts longer, like 2 years or more, courts might see it as too harsh. The geographic scope also matters. If the agreement covers an area where you never worked or where the employer does not have a presence, it could be considered unreasonable. For instance, banning you from working in a state where you never worked might not hold up. Restrictions should only cover activities that directly compete with your employer's business. They should not prevent you from working in unrelated fields. For example, if you worked in marketing for a clothing company, a non-compete that stops you from working in any marketing job might be too broad. Another important factor is what you received in exchange for signing the agreement. This is called consideration. It could be your job offer, a raise, or ongoing employment. Without something of value, the agreement might not be enforceable. Laws about non-compete agreements vary by state. Some states have strict rules or even ban non-compete clauses for certain workers, like low-wage employees or healthcare workers. Others requiring the agreement to be very specific and narrowly tailored. Courts can refuse to enforce a non-compete if it is too broad, vague, or was signed without proper consideration. For example, if an employer rushes to get you to sign a complicated agreement on short notice, it might not be valid. Employers can seek court orders called injunctions to stop you from working if you violate a valid non-compete. They can also ask for damages if they lose business because of your new job. But courts will weigh the employer's interests against your right to work and earn a living. In the end, whether your non-compete agreement is enforceable depends on if it protects a real business interest, is reasonable in scope, and follows the law. If you're unsure, it's a good idea to talk to a legal expert who can review your specific situation. Remember, laws change and vary by location, so knowing your rights and obligations is always smart.